She's an attorney, a law professor. Angie Marissa Porter, welcome back.
Hi, Karen.
How do we reframe our minds from calling it the George Floyd trial? I mean, it's just so weird that just rolled off my tongue.
Yeah, I know some people get really upset about that, but I don't actually, because I would rather remember George Floyd's name than his murderer's name. And, you have when I'm watching the McMichaels Bryan trial, sometimes you have cases with multiple parties, and instead your brain says, no, this is the trial about the murder of Ahmaud Arbery. He's front and center for me. I don't care about these white nationalists. So I get that. I don't think there's always bad intent there when we make that
no, definitely not.
I don't think there's bad intent, but yeah, I mean, we should always remember that Derek Chauvin is the murderer who killed George Floyd. So
I got Twitter sucked me into watching some of this trial today. And as I was watching it, I said, if Derek Chauvin got on because we talked about whether he would take the stand. And I feel like had he took the stand and started crying the way Kyle Rittenhouse was crying today, after listening to that jury afterwards on Don Lemon, they might have acquitted him.
Yeah, no, and you know what? I don't want to belittle that point, because I think you're absolutely right. I think given the right jury, because I've seen people responding, and I responded to your tweet about it too. But given the right jury, I don't care where it is. Could be Minnesota, which is known, the Twin Cities is known as a liberal bastion in the middle of the state. So be it. So what? Like, it could have been that they saw their uncle, their husband, their father, their cousin on the stand crying. And it really, you don't know. It really depends how they cried, when they cried. There's so many factors there. And I think you're absolutely right. They could have acquitted. I was not at all confident during that trial that Derek Chauvin would be found guilty. And it wasn't until I really thought about that one juror who I thought was not going. But short of that, I was not certain. So I think you're right. I do think, though, that these two trials are tangibly, palpably different in terms of who the defendants are. So I think it is much easier in the Rittenhouse trial for the jurors to look at this person as their darling, who felt his life was in danger and was fighting for his life and is still fighting for his life. I think that is a more widespread thought process. And we're in the state of Wisconsin, which in Minnesota, we know to be the state you don't drive through, you don't stop in, you don't eat at. I mean, this is a different.
Tell us about that. I'm from Jersey. I know, just because I did research, that Wisconsin is one of the most segregated. It is the most segregated state in our union. Wisconsin, not Alabama, Mississippi, Wisconsin.
Yep.
So clearly,
and Wisconsin people would come into Minnesota during the George Floyd and tear things up. It was those people from Wisconsin that were endangering people in Minnesota.
Yep.
So talk about that. That in and of itself leads to a racial dynamic. But race is not, unlike George Floyd, Chauvin, Ahmaud Arbery, McMichaels. Kyle Rittenhouse killed white people.
Yeah.
Does that matter? Or are those white people in the same category that Nixon saw the hippies who were anti-war? Are they the same kind of white people that, like they're allies, so therefore they're Wiggers? I'm putting up, air quotes around that. Are they outcast white people, so therefore they have the same value as a black person?
It's always about blackness in all these trials. Going back to your use of Wigger, I'll go back to an older term. These people, in the eyes of white nationalists, these protesters are in lovers. So they've crossed the line in the sand, and that makes them fair game. And I'm using the word game here in the hunting sense. They get to be hunted. So it's always about degrees of separation from blackness. We are still We're looking at a context of people protesting after the murder of George Floyd, after the shooting of Jacob Blake. Jacob Blake is at the center of this. Those folks were out there upset about that. And you have police who felt victimized, even though they're the ones who hold the ammunition in their guns. They felt victimized and they felt aligned with these vigilantes, the group of which Kyle Rittenhouse was a part. So it always relates back to Blackness, and anyone who tries to distract from that is doing what is very popular these days and is basically trying to obfuscate from the real issue.
Or gaslight us. 866-801-8255. Angie Porter's here. Tanya Pinkins is here. There's I haven't seen you in so long. I want to talk to you about so much. I want Tanya to get in as well. But you know, Kyle Rittenhouse said something on the he said a lot that made me, he's so well coached, but not really. He said, you know, I was there to protect my community. And the lawyer's like, but you're not from Kenosha. Well, my father's lives there. And the lawyer's like, a lot of people live in Kenosha. You're not from, this is not your community. And I came there to stop I came there to stop the graffiti and the fires with a rifle. Like, none of it makes any sense. It makes no sense.
No, it doesn't. And not any rifle.
I came to here to protect whiteness. I'm here to protect whiteness. You know what I mean? I'm here to protect my community. If they attacking whiteness, I'm here.
And it's not just a rifle. This is an AR-15 style rifle. And an assault weapon, it's over the top. And I don't want to trigger or traumatize anyone. I don't think this is a rough trial in contrast to Chauvin because of the imagery that's a little more graphic. But if you were to see what that AR-15 did to those people who were shot, this is not a weapon anyone should have. So that's also an idea that's central. That's a central theme in this case is, why does anyone have an AR-15, period? It is able to vaporize the part of the person's body that is shot. And so you don't just walk up in a protest with such a weapon, not intending to use it to kill. And that's really the point of the cross-examination today.
But look who is carrying that. These are people who hung people, burned them alive, carved up parts of their bodies, gave them out as souvenirs, brought their children to watch, took postcards and sent it. So for that community of people that it did all that, that probably is exciting to them. That is part of their culture of what they do to ends and end lovers.
Yeah, I mean, the white nationalist, white supremacist tradition doesn't care. That tradition revels in the violence, the mutilation, the deterrence that those horrific injuries and deaths create. I mean, people are probably scared. Anytime something like this happens, people second guess whether they should go to a protest.
And Kyle Rittenhouse said he was scared. He was scared that they were chasing him. And I tweeted, has anybody, raise your hand, if you would chase somebody carrying an assault rifle, who among you would chase somebody who has an assault? Because he was carrying it. It was very visible. All of the images I've seen of him, it is not like he tucks it away in his backpack. It was across his chest. So you're telling me that these victims, I'm going to call them victims because that's what they are. The judge, we're going to get to him in a second, Bruce Schroeder, that we're supposed to suspend belief to take Kyle Rittenhouse's word that he was being chased with an AR-15 across his chest.
Yeah, absolutely.
What has the prosecution called the people who can't be called victims?
By their name. And I'll come back to what you said too, Karen, earlier, but yes, by their name, Tanya. And I'll say, just from my legal perch that the same thing happened in the Chauvin trial, and the same thing happened in cases where I practice. The judge said, we can't call them victims because that's inflammatory. I think this is like a well-established thing. They said it's prejudging them. We have to prove that they were victims. And when I was doing medical malpractice work, it kind of made sense because you have to prove first what the cause was, and then you can say, okay, they were a victim. But so that part was upsetting, but it wasn't as upsetting to me as he in the same breath saying, we can call these protesters rioters and looters. That's also inflammatory language. And it's language that we know is associated with a specific narrative that's arisen out of these incidents. And so that to me showed his hand that he's a biased judge. And he's just acted in such a beautifully consistent way with my read of him being biased against the prosecution.
So you and I were talking before we came on air about the fact that, you know, lawyers have an option of doing something called requesting a recusal of a judge. They don't usually do it because lawyers have to practice in front of judges for in a career. And it is an insult to a judge to recuse him. It's also an insult to a judge to appeal him and get him overturned. So even with this biased behavior, the prosecution has not chosen to call for a recusal, but you were saying you didn't even think that they would appeal if Rittenhouse is acquitted.
Yes, and that's because typically that's just not in the procedural rules. The prosecution typically cannot appeal if they lose. So
even for judicial bias.
I'll have to look into that, Tanya. To be honest, I'll have to look into that, but it's not something I hear about much. So I think that they're sort of where they are. There are some instances when you can appeal in the middle of a trial. That's called an interlocutory appeal, but it's sort of extraordinary. So I don't know. I'll have to look more closely into that specifically, but we'll have to watch and see what this prosecution does. They are making a record. So they are thinking about, like if you watch the trial, they are saying, I would like to on the record say X, Y, Z. And whenever an attorney says that, that means they're thinking about a potential procedure in the future where they can rely on what they just said. So I'm sure there are things that can be done, but I'm not really seeing the obvious.
Well, I mean, if he's acquitted, there's double jeopardy. So he can't.
Exactly.
Well, there's wrongful death though, right?
Yeah,
you can't even do wrongful
what they
death.
did to OJ or a civil case.
Yeah, so a civil case can also come up. So that's a good reason to have a good record. The prosecutor is not thinking about a civil case necessarily because the prosecutor wouldn't be bringing that case, but perhaps he is. Maybe he's thinking of a federal case. I don't know.
Yeah, civil rights.
So there are things that, exactly, Karen. And I just want to go back to something you said too, Karen, about Kyle Rittenhouse being scared, even though he's carrying this deadly weapon. This is a common theme that I want everybody to think about in all these cases. Fear. Fear, fear, fear. It's where they always go. It doesn't matter if it's police. It doesn't matter if it's white nationalist vigilantes. They're always going to say fear. But the thing they don't say is that they became afraid in the course of a crisis of their own making. No one would have threatened or tried to attack. And I'm not saying that's what happened in Rittenhouse. That's what he's saying happened. But, let's assume, for the sake of argument, let's believe him for a minute. No one would have tried to attack you or would have threatened you if you didn't show up with this big weapon, fully loaded and ready to go at a peaceful protest, or even unpeaceful. Let's just assume it all. Nobody would have attacked you. So this is a crisis of your own making.
So let's listen to, there was an exchange today that I'm still stunned by, and I need y'all's perspective on this. It was between the prosecutor and the judge around the same thing that you just said, Angie Porter. Angie Porter's here, Angie, A-N-G-I, Angie with an I, Marissa, Maryssa, Mary with an SSA. That's where you can follow her on Twitter, Angi Marissa. So the prosecutor is saying exactly what you're saying. And the judge's response stunned me into, like, I'm confused right now. Smith, play that clip.
First of all, Your Honor, we have introduced evidence that the defendant had a slogan on his TikTok page, "Bro, I'm just trying to be famous." This case has made him famous, and he's posing for selfies as a result. One of our theories of this case is that his behavior that night was intended to gain attention, to be famous, and he's reaped the benefits of that. Second of all, he is on trial, in my opinion, for exquisitely poor decision-making. Taking a gun that he's not legally entitled to have, coming down in violation of the curfew, running around the community with that gun, trying to be a police officer when he's not, confronting protesters that he knows are hostile, and all of those behaviors, I think, are exquisitely bad judgment. So the jury can make that decision. The jury can give what weight they want to this evidence. But it's moments after he has a court appearance here. He's out on bond in this case when he decides to do this behavior. And nobody made him do it. Nobody forced him to go to the bar. Nobody forced him to wear the shirt. Nobody forced him to pose for selfies. It's his own decision making.
When I made reference to exquisitely poor judgment, I was talking about at the incident when he was wearing the shirt. Because, everybody in all of humanity at one time or another displays bad judgment, sometimes exquisitely bad judgment, and we don't let it into people's trials on unrelated matters.
What?
There's so much there. Okay.
First, just the word exquisite. I don't think any Black person has ever had any exquisitely bad judgment.
Thank you, Tanya. I agree. There are a few things going on in that clip, Karen. I'm glad you played it. First, the judge is trying to separate these incidents. So the incident that they're talking about is the 4 months later where Kyle Rittenhouse took a selfie wearing a free AF, but it was all written out, shirt. Mm-hmm. And that something came in about that being with some members of the Proud Boys, which they were going to keep out. The prosecution was going to keep that out and just say, let's look at the shirt and how this is bad decision-making because you've been charged with murder. And now you're out here being famous, like you said on your TikTok profile. Now the judge is distancing this. The judge is like, this is an unrelated incident. Do we even buy into that premise, first of all? I mean, the prosecution is arguing the opposite, that it's very related. It's related because it shows bad decision-making, but also is related because it's related to this case. His conduct related to him and how he acts in the public despite being on trial, being charged. So they just have completely different worldviews. And what I'm saying is the judge's worldview is very much aligned with the defense counsel and Kyle Rittenhouse himself.
I mean,
yeah.
Can we talk about Bruce Schroeder, the longest serving circuit court judge in Wisconsin, the longest serving. He's been elected, by the way. So elections matter. Elections matter. Y'all don't show up for judicial elections. This is what that looks like. He's 75-year-old white man from Wisconsin. Stop. The most segregated state in our union. Stop. Just process for a second. Who would he be aligned with? Is Kyle Rittenhouse's grandchild? Is he his great grandchild? Can he see him? Is that his great nephew? Kyle Rittenhouse, he cries. He looks to the court, looks to the bench.
Yeah. The jury.
Is this working? He went to Marquette Law School in 1970. He worked as a prosecutor and began serving as a circuit judge in 1983. His longevity is a subject of frequent conversation in the courtroom. And as he said during jury selection of this case, he said he's, quote, been in this business for 50 years. So he's letting you know, what is this business exactly? Miscarriage of justice? What is this business that he talks of?
The institution that is the Wisconsin courts.
Which I'm sure upholds whiteness. I'm sure that's probably one of its So tell us about this judge and how problematic. Because as I was sitting there watching it today, you know, Tanya, I'm sitting there thinking, how many of us have been in a court with a judge like this? And there's no recourse. They have ultimate power, pretty much. He kept interrupting the prosecution, asking him, why is he asking this question? I'm like, are you are you working for the defense? I was confused. It was weird. Then his phone goes off and it's playing. Did you see that?
Yes.
The phone goes off. It's playing God Bless America or something, like God Bless the USA. Like, what the? And is that a Trump connection? Like, what is happening? Okay, Trump's rally song plays as his ringtone. Somebody make that make sense.
Yeah, I think it makes perfect sense. I think it makes perfect sense.
Okay. So we're having this conversation today, and I don't want to be left, well, which we probably are, left feeling like there's no recourse here. You know, as we're watching this trial, I absolutely feel like Kyle Rittenhouse is going to be found not guilty. Those people who were murdered, and tell us a little bit. Have you seen the pictures of what was done? Just be alert, y'all. I need Angie to tell us what people look like who were killed because he killed two people. Right? He killed one person and injured another. He killed two people, right?
Yep.
He killed two people. Murder is illegal. He killed two people. He took their life, right? What did their bodies look like when he shot them? And they were unarmed.
They were unarmed, and he shot at one person who was armed. When I saw those images, and I've seen some pretty grisly images, but the thought that comes to me is every movie that tries to depict death and violence. Karen, I know you've seen Squid Game, and you and I both have seen that. Any violent fictional depiction can't come close. That's what I thought. They try and they cannot come close to these images. It's hard. It's seared into your memory when you see something like that. And if anybody has seen it, I just urge you to take care of yourself. But it reminds me that there was a total disregard for human life here. Total disregard. I wouldn't want to shoot an animal with a weapon like that. And I think there are a lot of people on earth who would agree, a lot of hunters who would agree. So yeah, it just makes me think, where are we where something like this can be done so easily in a fraction of a second? I think at the beginning of the trial, they were talking about how Kyle Rittenhouse fired 4 shots into Joseph Rosenbaum.
Oh my God.
In less than a second. How? He fired that gun at the person they call Jump Kick Man, who kicked him in the face, and we have never identified, apparently. I think he was a black man too. That man jump kicked him in the face and got away and said, I don't want nothing to do with y'all. But he fired 2 shots at him, missed. I'm sure he would have been seriously injured if he were hit. And then the sole survivor, Gage Grosskreutz, who did take the stand, he was shot in the arm once, but his bicep was 90% gone. And several months of physical therapy, his life is forever changed.
Is there, is the prosecution putting on the survivor as saying, no, we were not chasing this person. We were being pursued, we were being attacked. This person was hunting us and we were trying to keep him away from killing all of us because that's a gun that could have, are they putting that kind of argument on?
Yeah, the one survivor, Gage, that was his narrative exactly, Tanya. He's saying after they heard the shots that killed Joseph Rosenbaum, all hell broke loose. The crowd said someone is firing, there's an active shooter, and then you see this shooter running down the street, running towards police. Gage actually goes and talks to him. He doesn't know at first if he's the active shooter. So he's like, where are you coming from? Was somebody shot? What happened? And once he realizes that, he goes back, sees Anthony Hubert shot dead right in front of him. And I mean, Gage was like right behind this man. His arms are up, but he has a gun. He has a phone and a gun. Gage Grosskreutz was there as an EMT. He is an EMT. He was doing what Rittenhouse claimed to be doing, but Rittenhouse is not an EMT. He has his gun, a regular handgun, a Glock that he had concealed, and he's ready to, he doesn't know what he's about to do. When he testified, he's like, I wasn't ready to shoot him. I had my gun. He had his gun pointed at me. He reloads. What am I supposed to do in that moment? I'm not even thinking clearly. I'm thinking I'm gonna die. And then he's shot in the arm. So that's the only living narrative we have of what was going on. Anthony Huber is on video hitting Rittenhouse with a skateboard. They're trying to stop this man. So is Jump Kick Man. They're trying to take him down because he just shot somebody and is running off. So for them to reframe this as self-defense, I mean, totally expected when you're a defendant in a murder trial that you're going to have some sort of defense, but this is the absurdity of law. Law is mere ornamentation on these set of facts because we all know how this went down. We know why so-and-so was there. We know the type of weapon he had and the capabilities of that weapon. We know what he was doing after by running to the police, who sanctioned the presence of that militant group there, who said thank you and gave them water, who did not arrest Rittenhouse when they saw him with his hands up. We know the law is inadequate to address this. And I hope that's the key takeaway. As you said, Karen, I mean, that's really the takeaway. I will not be surprised if he walks. I'll be surprised if he's convicted of any of these charges. Perhaps the possession charge for a minor to carry the weapon will be the charge they come down on. But a lot of people didn't buy the crying. Now the counter argument is he was having a panic attack. So there don't need to be tears. It's just
so he's emotionally fragile, but he's not emotionally fragile to go into a riot or into a protest with a AR-15. So he's
right. And the key for me is when he became emotionally fragile. Okay, this is not a case where the defendant breaks down crying with remorse because they took a life. That is not when Kyle Rittenhouse cried. He cried when the defense attorney asked him to tell him what happened right before he shot Joseph Rosenbaum, which is, he was crying because he was reliving the terror, air quotes, terror, not because he felt I took a life and I did something wrong. And even then, we would be incensed because of your point. You weren't crying when you were there with an AR-15. But even in this trial, he's not even crying with remorse. He's just having a PTSD type response to being chased. So that just makes it all the more ridiculous. It's not something that I would empathize with.
Wait, as he's crying, though, he's looking at the jury too. Like,
oh yeah, he did glance over the jury.
Are y'all catching this performance? Please
He
see
did
me as
glance.
sympathetic. I'm just a boy trying to live my life. All right.
And even if he's not acting, that's my point. Even if it's totally real, okay, you're having a panic attack. You're having a panic attack,
right?
Not for killing them. You're just
not for taking a life
because you got chased. That is not a sympathetic cause from me.
We're here with Angie Porter, Tanya Pinkins. We're talking about this Kyle Rittenhouse case. I have not seen a judge. Again, prosecutors and judge usually dance together. What was this, Angie Porter? They don't normally dance together, Tanya?
Can I
Yes.
just speak? Because, you know, what you see on TV shows is just make-believe. The way that judge talks is the way I have been in every level of court in like 20 states. That's usually how I hear judges speak to anybody who they ain't agreeing with.
Well, I think my little Minnesota experience is different. I've dealt with some rough judges, and I've seen some cases where the judges seem to be just totally unfair. But, the occasional blow up, okay. This has crossed into a new form of theater for me. It's like, how much do you have to yell? You are the judge of this court. You have all the power. You could speak in a whisper and still make the same impact. So to me, I'm looking at Judge Schroeder like, you're not even going to attempt to veil, not even thinly veil your bias here. It's one thing, I think, if the judge is generally moody and is like going in on both sides and all the attorneys are like, but he's really going in against the prosecution. It's not only that, it's not only the yelling, it's the interruptions, the incessant interruptions that, in my opinion, are gratuitous and over the top. Like, it's not just mediating objections. It's, is it too cold in here, jury?
I saw that. Yes.
Yeah. Oh,
In the middle of the questioning, though.
In the
Angie.
middle of cross. Absolutely, Karen. And so it's like, now you're just off the rails. You're not even attempting to appear unbiased here. And if you are, you're so biased. Anyway, I'm sorry, Tanya.
I have seen this. That is what I heard was just de rigueur in the hundreds of cases I sat in courts. And I'm usually there for somebody who's, a respondent who's not winning, but I have libraries full of transcripts that's what I'm accustomed to judges, the way they talk, the way they don't let people speak, the way they insult them. That, to me, that is normal. I'm accustomed to that.
Wow.
All right. So before we went to break, Angie promised some hope. So I'll live for that.
I hope I didn't overpromise. I'm looking at the Rittenhouse trial like, I don't have any hope for this trial, in this specific trial, this specific proceeding. But there are some other proceedings that are live. Jacob Blake, even though he moved away from Kenosha, even though no charges were filed against the officer who shot him, he's still alive out there and he's still fighting. So he has a civil case that is live against the city and the police department for excessive force. See what happens there. Gage Grosskreutz, the sole survivor of the Kyle Rittenhouse shootings, also has a federal case that's live, and it alleges not only not excessive force, but it actually might allege excessive force. But the really interesting allegations for me in that case are the constitutional ones. Equal protection clause is in there. And his argument, which is in his complaint, is that if Rittenhouse were Black, the police would have arrested him, they would have shot him. That's one of the arguments. The other one is First Amendment, freedom of speech. Under the First Amendment, you're not supposed to censor speech of some people based on their viewpoint. And so Grosskreuz's argument is that you had the protesters and you had the vigilantes out there. They shot rubber bullets and they pushed back protesters for being out there past curfew. The vigilantes are also civilians out past curfew, but the police didn't do anything to tell them to go home. And so his argument is this is viewpoint discrimination. You're attacking anti-police, people you deem anti-police, and not, you're protecting rather people who are pro-police. So that is a really interesting case. And I'm hoping to watch that case and see how it unfolds. There's also a proceeding I've heard against Dominic Black, the person who bought the gun for Kyle Rittenhouse. So we have some other things going on, but I just don't know about this trial.
I got a question for you as a lawyer. This is something friends of mine have been playing around with for a while. Why is there no life interest argument? People having an interest in their life. The Constitution says pursuit of life, liberty, and the pursuit of happiness. But nobody has argued constitutionally, I had an interest in my life, and that interest survives my life, and someone should have an ability to come before a court and argue that I was deprived of my life interest. Since our Constitution says we have that right.
Yeah. You know, I don't want to dive into the thicket of all the technicalities of constitutional law, but I do think that that interest in life, as you point out, Tanya, it permeates. So, you know, as the McMichaels and William Roddy Bryan are on trial in Georgia right now, that's their state trial, but they have a federal trial coming out, and it is constitutional. It's hate crimes. And that's also sort of an equal protection thing. A life was taken. A life was taken based on discriminatory purposes. That's going to be an interesting trial too that plays out. I think too that the Constitution sort of backs off when the state fills in the void. That's just a general underlying concept with constitutional law. So it's sort of, think about it like the pandemic. You have this federalism thing. Federal government, we're not going to do anything because the states are going to do it. Well, the problem arises when the states don't do anything. And so theoretically, federal law says we don't really get into this space of murder and things because the states have their own laws that address murder. And that's what we're looking at now. But what happens when the state doesn't adequately address these things? And yeah, that's the gap we're left in.
Right, really? Somebody got to argue it so that it can exist. Everything at the law is arguable. Somebody's got to argue for federal life interests so that they can come down to the state.
Mm-hmm.